Good morning and welcome into another episode of the After Parties Me the Jury segment. I am Tam, your host, not your lawyer, but your nosy best friend. And this is where you come to get all of your courtroom tea served piping hot. Thank you so much for joining me again on another beautiful Saturday morning, while we continue to chip away at the Karen Reed Trial 1 sidebars. Today we are going to be checking out days 10 and 11 and seeing what Auntie Bev is up to today. We are not going to delay. We're going to get right into it. We have 1 hour to go, and we are not going to go overtime today because I got something to do. So let's get right to it.
Persons having anything to do before the Honorable Beverly Canoni, Justice of the Superior Court, holding in Denham within and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated. Thank you. May be seated. Code is at
22117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves, please?
Adam Lally for the Commonwealth. Good morning, Your Honor.
Good morning, Mr. Lally.
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
Good morning, Your Honor. Alan Jackson for the street.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of the street.
Good morning, Ms. Little.
Good morning, Your Honor. Giannetti for Karen Reed.
Good morning, Ms. Giannetti. I'm told there's an objection to something you intend to use during cross.
Yes.
Do you want to come over?
Sure.
Right out the gate, sidebar number 1. They're not wasting any time.
All right. So we are all set to begin.
This is similar to the video that both counsel and the court ended up indicating they have an objection to the bulkhead to fence to the front yard. I had my investigator go back out. The court had indicated that we should have done it with the investigator and nobody else was in it. We did exactly that. All it is a video from the bulkhead. He opens up a bulkhead door.
Is there sound? Is there audio?
There is no audio. The audio has been stripped.
Okay.
He didn't talk on it anyway. I wasn't there. He took the video from the bulkhead. He turns, walks to the fence, goes through the fence and walks to the front yard, and that's it.
Yeah,
It's probably 15, maybe 30 seconds long.
It's about 51 seconds long. Your Honor, the objection is, and obviously this is within the discretion of the court, but relevancy grounds. I don't know of any witness that puts Mr. O'Keefe in the house, let alone in the basement, in the area of the bulkhead, anything to do with that. So for that reason, the Commonwealth would object on relevancy, as it really is just cause to confuse and mislead the jury about whether or not Mr. O'Keefe. There is no indication that the bulkhead is at all relevant, as Mr. O'Keefe wasn't in the house and wasn't near the bulkhead.
Well, that's their theory, that he wasn't in the house.
Explain the relevancy.
We believe that there is evidence that Mr. O'Keefe was in the house. There is strong evidence that he was in the house. That's probably coming up either today or tomorrow.
Make an offer of proof for me.
Do you know what eating banana can do to your liver? Bananas are actually edible when they're...
Ryan Nagel and Heather Maxon both saw John O'Keefe. Both saw John O'Keefe and Karen Reed in the car together when they turned almost simultaneously onto Fairview from the adjoining street to the north. When they pulled up, both witnesses will testify that based on their looking at the phones, they started paying attention to the house. It was Julie Nagel who started to make her way out of the house. They were there for about 5 minutes, 10 minutes, talking about Julie Nagel. Julie Nagel then goes back into the house, decides to stay. She doesn't want to ride home. And as they leave, both Ryan Nagel and Heather Maxon indicate they looked into the interior of Miss Reed's SUV. John O'Keefe was not there. Miss Reed was sitting alone, with nobody else in the passenger compartment. They will both say they did not see him standing outside the compartment. He wasn't on the street. He wasn't on the sidewalk. He wasn't in the yard. The only other place he could have been is in the house. If he was in the house, then there is reason to believe that he was in the basement. There is an exit from the basement to the backyard, serving the very area on the same side of the house where John O'Keefe's body was found. That is the defense's theory. That's been the defense's theory from the beginning. The Commonwealth has a different theory, that there are 7 witnesses, 9 witnesses, all of whom walked out of the house or in the same way looked out of the house and no one saw John O'Keefe's body in the lawn, which is where they claim he would have been at the time every single one of these people passed by the lawn or looked out onto the lawn. The only other place he could have been is in the house.
And what about him being in the house? If that's true, then what? You need to give me some more.
If he was in the house, then the most reasonable place for him to be and be injured is down in the basement. There is a slab flooring down in the basement that's made out of concrete. That would answer the question how he got the fracture on the back of his head. The lacerations to his eyes, the black eyes, the bloody nose will indicate a fight.
Ooh.
We've got evidence, and we've got experts who are going to say that he looks like he was in a physical altercation, not hit by a car. If he was in a physical altercation that nobody else on the ground floor saw, the only other place he could have been is upstairs or downstairs, such that they would not have witnessed the actual fight or the physical altercation. The most reasonable place for him to be is down in the basement, and the basement services the very side of the house where John O'Keefe's body was found. We would want to be able to show that and establish that the bulkhead is a place where if you wanted to remove something large and heavy, you could easily do it. And if you did do it, that would end up right on the same side of the house where John O'Keefe's body was found.
All right. So apparently there is a third-party culprit inside the house?
Correct.
And who might that be?
Anybody.
It's unknown. It could be one of several people.
Yes.
So under the third-party culprit doctrine, I do think this is speculative, but I am going to let counsel explore this. So I'm going to let the video in.
I understand.
Okay? So the Commonwealth's objection is noted, but he has to authenticate it.
Understood.
This wouldn't pertain to you guys, but Mr. Kearney is in the courtroom. He cannot view this witness, correct?
Correct.
Okay.
So we will bring the witness in, and he's going to be removed. All right.
Thank you.
All right, so we're all set to begin?
Yes, Your Honor.
Okay. Bring the jurors over.
At that June 2023, and I'm going to talk about a couple of dates, so I don't want to be confusing. At that June 2023 non-Commonwealth hearing.
Okay, Lorenzo, this is a great question. Did they check for DNA inside the home? No, they did not. They never searched the house for any evidence that there was a fight or that John had ever entered the home. They only interviewed the participants of that party that night. They didn't search the home. And the only search that was ever done of 34 Fairview was done by the defense, Karen Reed's defense, and their private investigator.
You were asked some questions about whether or not you knew Karen Reed before January 28th, 2022.
I believe
Second question.
I believe so, yes.
And you testified, before you testified, you were sworn an oath.
Yes.
Same oath that you swore in this trial, correct?
Yes.
You swore to tell the truth, the whole truth, and nothing but the truth?
Yes.
And you knew that you were testifying under penalty of perjury in that hearing as well, correct?
Yes.
And you testified at that non-Commonwealth grand jury that you, quote, believe Karen was with John the night he came into Hillside, a female that looked similar to Karen from the waterfall came in with him on that night. And I assume that was her, but I can't say for sure. End quote. That was your testimony before that grand jury.
Yes.
But you were also asked a similar question in April of 2022 by Mr. Lally at his grand jury. You remember that?
No.
Let's start at the beginning. Before you testified in the April 2022 grand jury, more than a year earlier.
Brian Albert testifying.
And just 3 minutes after this incident, you were sworn an oath, correct?
Yes.
The same oath that you took in June of 2023, right?
Yes.
And the same oath you took on Friday.
Yes.
Isn't it true that you were asked the question whether or not you knew Karen Reed on January 28th, 2022, and you testified, quote, I've never met, or seen her before, end quote.
No, I don't recall that.
Didn't you indicate that you just that you reviewed your grand jury testimony in anticipation for this trial?
Yes.
You read the whole thing?
Yes.
And you don't recall making that statement?
No.
Walking makes
They
you
don't.
old.
They use I don't recall.
Tai Chi
Often,
makes you
okay?
young.
If you want to get away
Make it
with
a
something
habit.
you don't recall.
Yes, and I'll see counsel at sidebar when you leave that with the witness.
Already?
Just please take a look at that.
Sure.
This is number 2.
Okay. So I allowed the motion to stay away from the federal grand jury, and we were here at sidebar. I instructed Mr. Yannetti that he could say the grand jury, different date, and Mr. Lally wasn't there. Do you want me?
Is that not accurate? It's a non-grand jury.
But it gives the impression. I've already ruled on it.
It gives
All
the
right.
impression of what?
Well, that's why I'm telling you.
Okay.
So it's grand jury date. And I'd let you get into Mr. Lally wasn't the prosecutor.
If I am consistently asking about both grand juries, can I say the other grand jury?
Yes. Just not Commonwealth.
Okay.
Yeah.
Yeah, Coach John?
Yes.
Ms. Albert, have you had an opportunity to do that?
I have. Thank you.
Does that refresh your recollections to what you said before the grand jury in April of 2022?
Yes, but you didn't read the whole. You didn't read the whole quote, though.
Right. The whole quote is the following. Question. So the female you had never met before, is that fair to say? Answer. No. I've never met her or seen her before. Period. Maybe once, but I don't think I've ever had a conversation with her. That was the entire quote, correct?
That's the entire quote. Yes, that's not what you read earlier, but yes.
Well, what I read earlier was, I've never met or seen her before. Those words came out of your mouth, correct?
That's not my whole sentence. No.
You said, I've never met or seen her before, and then you said, maybe once, but I've never had a conversation with her, I don't think.
Right. That's my sentence.
Okay, so which is it, Mr. Albert? What were you saying? Were you saying you met her and had a conversation with her? Or were you saying, I've never met or seen her before? Which one of those two things was true?
I was saying that I met her maybe once.
Somebody might want to clean up blood at a scene.
No.
Objection.
With the answer stated.
What about sanitizing a location?
Objection.
I'll allow it.
No.
What about getting rid of electronic data? You've got to have training in that.
No.
In other words, the fugitives that you chase down and try to find, you don't try to utilize electronic data to go after them?
Sometimes we do, but I don't have any training in it per se.
I mean, things like GPS data and phone calls and text messages, communications, things of that nature, obviously.
Yes.
Here. These are all things that, at least those things, are things that if you didn't have formal training, you got on the job training and just have common sense about how to go after this type of evidence, correct?
Yes.
Sir, you had an iPhone with a number ending in 0888 back in January 2022, did you not?
Yes.
How many years did you have that iPhone as of January 28th, 2022?
Several years. I'm not sure how many, but multiple years.
And Mr. Albert, you were notified by the Commonwealth that on September 23rd, 2022, in the fall of 2022, a judge specifically ordered that you were to preserve that phone.
Objection, Your Honor.
Data, correct?
I'll see counsel at sidebar.
Number 3. Okay. Lincoln is.
So the nature of the objection.
So I'm going to pause right here. So this witness that's on the stand is Brian Albert. He is the homeowner where John's body was found. Okay. When he was asking him about whether or not he said he had ever met Karen before, the reason why this detail is important, it's not important whether or not he met Karen before that day. What's really important to note is whether or not you can believe what he says. Is he a liar or not? Is he telling the truth? Can you trust this man? And so that's the reason why they're asking that particular question. Right now, he is questioning him about his cell phone because Brian Albert and Brian Higgins, who both were there the night that John was unalived, they all got rid of their cell phones, and they were told not to conserve the cell phones, and they all got rid of their cell phones. They destroyed them. They took the card out, destroyed that, threw it separately and apart from the phone. Like, they completely destroyed the phones. So these guys are law enforcement. They know if you are given an order to preserve an item, that means you can't throw it away. And yet they did, and there's nothing that happened to them because of that. So I hope that helps to get you up to speed with where we are. We are on sidebar number 3. Let's go.
Your Honor, again, I think it's relevancy and hearsay. That's all.
It goes to his state of mind, Your Honor. The Commonwealth actually was the entity that gave him notice that he was not to get rid of his phone or...
Okay, sorry. So Lorenzo is asking, what is the difference if he says Commonwealth or not, right? The reason why this is important is because there was a federal hearing happening about this trial, and they do not want to reference, the judge has ordered that they cannot reference this federal investigation because they feel like it would prejudice the jury, that if they think that there is some federal investigation, then they'll automatically assume that there is some wrongdoing happening in this trial. And so in order to get a fair trial that's not partial one way or the other, she doesn't want this federal hearing mentioned at all. So that is the reason why she's like really hounding them about their wording and not trying to slip up and slide in there that there was some other trial happening. I hope that helps. Okay.
Any of its electronic data. His state of mind, and do so anyway, notwithstanding that notice, is highly relevant. He's been questioned.
Is he going to have to talk about he did this with advice or consent of his lawyer?
I have no information about that. I can tell the court he's testified to this before, and he never mentioned anything about that.
But I'm wondering if that's part of it. I know he didn't mention it before, but I'm wondering if that's part of it. He's got a lawyer here.
I don't know.
I would maneuver around that. If he says, I had a conversation with my lawyer, I'd say, don't tell us anything that your lawyer said. It's not up to his lawyer to thwart a judicial order.
You know what? I want a short voir dire on this.
Okay.
And we can bring his counsel in if he's here.
Can we wait until he invokes his counsel? I don't think he's going to.
Let's have a voir dire on this. I'm going to send the jury out. But that's the issue on this.
Okay.
She wants to have...
Capitalism was never designed to help you thrive. It was designed to keep you exhausted.
Questioning him about part of the jury. A voir dire is basically a questioning. It's like it's a separate hearing within the hearing where they can get to the bottom of something. They can try to pull out details to see if they can use it in the trial. Or let's say they voir dire an expert. It could be to figure out whether or not they can be considered an expert in the trial. So that's what she wants to do so that they can figure out what he's going to say before he says it in front of the jury, and then taints the jury because, you know, once you ring the bell, you cannot unring it. So that's what's happening now.
All right, and I am going to see if his counsel here, he has a right to be present in the courtroom.
May I step up for a moment, Your Honor?
Sure. All right, so Mr. Jackson, you can have a voir dire.
Albert, you're currently represented by Mr. Henning.
Yes.
Seated behind me. Gentleman in the,
Yes.
in the gray suit. Correct?
Yes.
Okay. Without telling me anything you've ever communicated with him, when did you hire him as your lawyer?
I'm not exactly sure of the date.
Give me a time frame. Let's see if you can narrow it down.
2022. I'm just not sure the exact date or even the month.
For the end of 2022?
I'm not sure. I believe prior to some of the other testimony that I gave. So prior to
April of 2022 at the state grand jury?
No, prior to the other testimony.
Okay, that was in June of 2023. That's my question. Did you hire Mr. Henning in 2023 in anticipation of giving testimony in June of 2023?
I'm not sure of the exact date. I believe it was
I don't recall.
maybe the end of 22. I'm not sure.
Well, did you get a subpoena for the other hearing?
I did.
Okay. Did you hire Mr. Henning after you got that subpoena?
I can't say. I believe so. Right around that time. Yes.
Okay.
I'm just trying to remember the time, and I can't remember it.
Okay. So you did not hire him. Well, you're all right. I think that answers the question. You're not represented before you.
I'm going to see at sidebar about the extent of the inquiry.
Sidebar.
Just so we can complete a record. So if you put the dates on and your concerns, I have a concern about a Fifth Amendment issue. He's got a lawyer. If he's going to sit here and say, I was told I had to keep my phone and I didn't do it. So let's lay out the dates and have a more complete record.
Yes, Your Honor. The dates, as I know them, is the subpoenas went out for I'm going to continue to call it the other grand jury.
I think we should call it another proceeding, and then that will differentiate it with the jurors as well. I think that was my original ruling on the motions.
Okay. The other proceeding. Subpoenas went out in the spring of 2023, maybe the late spring of 2023, at which point many of the individuals, again, giving them lawyers, they did not have lawyers that I know of in April of 2022 when they testified with Mr. Lally at the state court grand jury. This particular incident, this particular notice was signed by Judge Krupp on September 23rd, 2022. And I believe his testimony is going to be something along the lines of, toward the end of that month, without a specific date, he got rid of his phone in September of 22, well before he would have had any opportunity to or reason to hire Mr. Henning.
Okay, so it wouldn't have been after consulting counsel, but there is still the Fifth Amendment issue now, right? Not a court order.
I agree.
So I'd like it if you intend to do that question. I'd like you to do that for purposes of voir dire.
Okay.
Just in case his lawyer says he should take the Fifth.
Understood.
All right.
Thank you.
Just in case his lawyer tell him to take it.
Yes.
Thank you. You had received I want to draw your attention to 2023 now. I'm sorry. Now I'm doing it. The fall of 2022, September of 2022.
Yes.
Did you receive a notice on Commonwealth letterhead indicating that you were not to destroy or in any way manipulate any data on your cell phone, destroy the phone itself, or to manipulate or destroy any data on that cell phone?
I do not remember getting that letter. No.
I'm going to read this for the record, Your Honor, if I may, with court's permission. Yes. Did you receive a letter that said, in essence, not even in essence, it should be quoted as the following, quote, You, Mr. Albert, are hereby notified that the defense in the case of Commonwealth versus Kieran Reed, Norfolk Superior Court, criminal case number 22-117, has filed a motion pursuant to Mass R. Crim P. 17.
I'll tell you what, most people are going to walk into 2026 still asking AI random questions like it's Google. Here's what the...
For the production of any cell phones that you used between January 28, 2022 and February 28, 2022, and or any data associated with those cell phones, period. The hearing on Ms. Reed's motion will be held on October 3, 2022 at 2 p.m. in courtroom 1 of the Norfolk Superior Court. You may be heard on the motion at that time. You are hereby placed on notice that these cell phones are the subject of pending litigation, and you must not alter, delete, destroy, or in any way manipulate any of these electronic data associated with the cell phones at issue. Period, end quote. Did you receive a notice from the Commonwealth with that language?
I don't remember receiving that document, no.
Were you told in any other capacity that you were not to get rid of or delete your cell phone? In other words, preserve your phone.
Subsequent to me upgrading my phone, I spoke with the DA's office. So after that, they told me via a phone call that that was the case.
So your testimony is you never received the notice that I just read, but you did talk to the DA and he told you to preserve, you were on notice that you were to preserve your phone.
After.
I know you want to say that, Mr. Albert. My question is, did you have the conversation with Mr. Lowry?
Yes.
Okay. When was that conversation, sir?
So I don't have the exact date of the conversation. I'm not sure.
Who did you talk to on the phone exactly? Was it Mr. Lowry alone or was it a conference call?
It was a conference call.
Who else was on that conference call?
I believe Steve Nelson and other witnesses in the case were on the conference call.
Can you name those witnesses for us?
I believe it was Brian Higgins. I believe Jen McCabe, Matt McCabe, and maybe somebody else, but I can't recall.
Who initiated that conference call?
I believe it was somebody in the DA's office, so either Mr. Lally or Steve Nelson, somebody like that.
Did everybody just call into a central number, a conference line?
Yes.
And what exactly did Mr. Lally say to you during the course of that conversation about preserving your phone?
During the conversation, Mr. Lally said that the defense had filed a motion to ask for the phones to be preserved.
And anything else?
That's what I remember him saying.
Did you volunteer that, oh my goodness, I just upgraded my phone last week conveniently. I don't have that phone anymore.
No.
You didn't say that to Mr. Lally?
No.
You just took the information that he gave you and hung up the phone and went about your business?
Yes.
Without notifying him that the very phone that he had just ordered you to preserve had just been destroyed days earlier.
No, the phone wasn't destroyed. I upgraded the phone.
The data was destroyed, sir. Correct?
I did not destroy any data on any phone.
Mr. Albert,
I upgraded my phone.
when you upgrade a phone, you know that the phone is set back to factory reset before your new phone is handed to you, correct? Happens every time.
I don't know that.
So if you have personal texts with your doctor, personal communications with Mr. Henning, your lawyer, you're just going to hand that to a pimply-faced kid at Best Buy and say, here's my phone? You know that data is destroyed when you upgrade your phone, right?
I think some things are come over across contacts, things like that, so I don't know that for sure.
You can back up your data, sir, but the phone data is destroyed for all purposes. It's factory reset, correct?
I don't know that.
How long have you had a phone? That's an iPhone.
Years.
How many times have you upgraded your iPhone?
Multiple times.
Every single time you upgrade it. You know that the phone prior, the data is destroyed on it, correct?
Usually my contacts come over and my photos come over. So
That's a backup.
no, I don't think I have that on backup, but okay.
Irrespective, you didn't tell Mr. Lally that you had gotten rid of that phone.
I was not asked that and I didn't tell him that.
I I see. You felt like if you weren't asked that, you didn't need to volunteer it, even though the conference call was specifically about preserving your phone pursuant to a judge's order. Correct?
What was the question?
You didn't offer to Mr. Lally that you had gotten rid of the very phone that he was telling you had to be preserved due to a judge's order.
I did not.
And you didn't seek any advice from, I'm not asking you for the communications. You did not seek any advice from counsel at that time for those purposes.
I don't believe I did, no.
Sure.
Jesus.
If you're a Christian thinking about starting a business, don't. Starting a business is a terrible idea.
At some point, you indicated, Mr. Albert, at another proceeding, under oath, in relation to a conversation that you had with Brian Higgins about your phone. Quote, I don't recall saying I was going to get rid of my personal phone to Brian Higgins. I may have said that, you know, there's personal stuff on my phone. But I don't recall saying that to him, but I don't know. We had multiple conversations about things. Remember saying that under oath at another hearing?
Yes.
You literally admitted at that hearing there's personal private data on that phone. Hence, you got rid of it, right?
No.
You certainly wouldn't allow some kid at the AT&T store to have your personal private data. You're a cop.
No, I assume he doesn't have it
Why would you assume that?
because he took the phone and has it.
And what do you think happens to the data on the phone, sir? Let's just use common sense. What do you honestly think happens to the data on the phone when you turn it in and upgrade your phone?
I'm sure that the data's not there anymore. I'm sure.
It's destroyed, sir. Correct?
I don't know that for a fact. I know that some things are transferred back to the new phone.
You just said, you know the data is not there.
Some data, I guess, isn't. Yes.
No, that's all I have.
All right, Mr. Lally, any questions?
No, Your Honor.
Okay. All right, I'm going to take a short recess. I want to let this witness, if he chooses to have a few minutes.
Recess. They need a breather. Sheesh.
All right, Mr. Jackson, go right ahead.
Thank you, Your Honor. Mr. Albert, you were notified by the Commonwealth that on September 23rd, 2022, a judge specifically ordered you to preserve that phone.
Okay, so that was the end of the voir dire, and now we're back to the regular testimony, I believe, in front of the jury, okay?
And all its data. The phone ending in 0888. Is that right?
Yeah. At what time are you asking me that I was notified?
That day or the next?
On the 23rd?
On the 23rd or the 24th of September?
No.
Isn't it true that you were provided a letter by the Commonwealth that stated the following? Your Honor, if I may read this.
Yes, there's no objection.
Thank you. Quote, you are hereby notified that the defense in the case of Commonwealth versus Karen Reed, Norfolk Superior Court criminal case number 22-117, has filed a motion pursuant to Mass R. Crim P. 17 for the production of any cell phones that you used between January 28, 2022 and February 28, 2022, and or any data associated with those cell phones. The hearing on Ms. Reed's motion will be held on October 3rd, 2022 at 2 p.m. in courtroom 1 of the Norfolk Superior Court. You may be heard on the motion at that time. You are hereby placed on notice that these cell phones are the subject of pending litigation, and you must not alter, delete, destroy, or in any way manipulate any of the electronic data associated with the cell phone at issue. You received, end quote, you received that notice on either the 23rd or the 24th. Is that right?
I did not.
Your Honor, I would pose a stipulation. I spoke with counsel off the record, if I may.
You both have a stipulation that I haven't seen?
We just determined I'm happy to approach it.
Why don't we approach quickly?
This is number 5.
What is the stipulation?
Mr. Lally was kind enough to confirm that he and his office did send this notice either on the 23rd or the 24th of September.
Okay, so that it was sent, but not that it was received?
Correct. I can't make him read it. They don't have a copy of the letter that was sent. I think a stipulation is cleaner. I simply want to enter into the record that the Commonwealth sent it. If he claims he never got it, so be it.
Okay, so what exactly was the stipulation? What are you going to say?
I would propose the following stipulation, that the Commonwealth on either September 23rd or September 24th, 2022, sent a letter on Commonwealth letterhead stating exactly what was just read into the record.
Okay, don't read it again.
I won't. No. That what was just read into the record was sent to Mr. Albert on either the 23rd or the 24th.
Okay, that's the stipulation.
That's it.
That's fine. I don't have an issue with that.
Okay.
Thank you.
Now, yes, I would offer the following stipulation that on either September 23rd or September 24th, the Commonwealth sent a letter on Commonwealth letterhead to Mr. Albert's attention, stating exactly what was just read into the record pursuant to the court order dated September 23rd, 2022.
Okay. All right, next question.
Thank you.
Which is so unprofessional. If you send a letter of this magnitude, that someone should preserve their cell phone for evidence in a case, why wouldn't you have it a certified copy sent where they have to sign for it, where you can prove that they actually received it? Why wouldn't you do that? Why would you just put it in regular mail? This is so tacky.
Isn't it true that you were in fact ordered to preserve your cell phone by the Commonwealth?
At some point, I was made aware of that, yes.
All right, let's just get to the brass tacks. Where's your phone?
My phone was upgraded and traded in for a new phone.
Your phone was upgraded and traded in for a new phone.
Yes.
Okay. Another way to say that is you traded your phone in and got rid of it, correct?
I traded my phone and upgraded it. Yes.
When did you get rid of your phone ending with 0888?
I upgraded my phone in September, third week of September, maybe around 22nd.
The 22nd of September.
The 22nd!
I believe so. I can't be sure the exact date.
So, according to you...
That's the sound of an American oil company hard at work. Want to be a part of it? Listen up.
Hello.
You got rid of the phone that was the subject of a court order preservation the day before it was ordered preserved. Right?
You literally can't.
Rephrase the question, please?
This order was just stipulated. This order is dated September 23rd, 2022. It was just stipulated that on the 23rd or 24th, you were then sent a notice to preserve the phone. And your testimony is on the 22nd, the day before this all happened, you upgraded your phone and got rid of it in total, correct?
I upgraded my phone on and around the 22nd, yes.
And you knew that all of the data on that phone would be factory reset and destroyed.
Objection.
Do you know that, sir?
I do not know that.
How many times have you upgraded your phone and your iPhone?
I'm not sure. 4 or 5 times, maybe.
You're aware that when you turn a phone in and you upgrade it, the phone that you turn in, that data is factory reset, meaning it's gone. It's destroyed off of that device, correct?
Well, I think some data transfers and some doesn't.
We're not talking about a backup. I'm talking about the physical phone. That physical phone becomes a brick when you turn it in, correct?
Correct that it becomes a brick? I don't know.
It becomes effectively a brick. There is no data left on the phone. I'm not talking about backup data onto a cloud. I'm talking about that phone.
So the old phone, yes.
Yeah, it's just everything on it's destroyed, correct?
Right, although some of the data transfers to your new phone.
And you're aware that that the very
In your
data
contact.
that you were ordered to preserve would have been destroyed, according to you, the day before. Correct?
Rephrase your question or ask me a question.
Are you claiming that you got rid of your phone on the 22nd?
I upgraded my phone around that. I'm not sure if that's the exact date, but yes.
So it could have been after the 22nd.
I don't think it was after the 22nd.
Could have been the 24th?
No.
Could have been the 25th?
No.
So you're absolutely sure that you could not have upgraded your phone and gotten rid of it anytime after the 23rd when this judge ordered that it be preserved?
No.
Because you know that if you got rid of that phone after you had been notified that you were ordered by a court to preserve it, you'd be committing a felony.
Objection, Your Honor.
Sustained.
What? What's the objection? What's the legal standing?
So you now claim that you got rid of the phone on September 22nd, 2022. Hours before you were ordered to preserve it. That's your testimony, correct?
Yes.
Is that just a coincidence?
September 4th was my birthday. The phone was broken and failing. I had planned on getting a new phone, and that just happened to be the day that I got it.
Happy birthday. Was that a coincidence?
Objection.
Sustained.
Not happy birthday.
Are you saying that from your closed and locked phone, you inadvertently tapped your phone one time, and that initiated a butt dial to Brian?
Objection.
Is that really? Okay, really quickly, because some of you I know did not follow this trial at all. So between Brian Albert, and Brian Higgins, which were the two guys that were fake sparring in the bar, there were phone calls made the night in question or the early morning hours before and or after John O'Keefe was unalived. There were phone calls between them. They claim they never made any phone calls to one another, but there are phone calls in the call log between these two individuals. And then they tried to say, well, maybe it was a butt dial, but it was butt dials back and forth, at least 3 between the two of them. And some of them lasting more than a minute long. You know that if it's a butt dial, it's not going to last that long. So they are just trying to show the jury reasonable doubt. You guys were calling each other back and forth, almost in a frantic kind of way. And now you're saying, oh, we both got rid of our phones. Sorry. Yeah, right.
You're saying?
No, that's not what I'm saying.
Tell me what you're saying.
I-
How did you butt dial Brian Higgins?
I don't know.
22 in the morning.
I don't know that the phone was locked. I could have been looking through my phone. I butt dial people often and make inadvertent calls.
You got a big butt.
I could have hit a last call from him by accident,
You got a gym.
thus calling his phone.
So you were actually awake and on your phone at the time.
I was awake, and I could have been looking at my phone.
So Mr. Albert, how'd you miss the call 17 seconds later?
Well, my wife was in the room with me, and we were hanging out, and I never got the second call from him. So I'm not sure what time he called. I'm not sure what I was doing at that second, but I don't know.
Hanging out.
But it didn't go to voicemail.
Well, I didn't get a voicemail from him, no.
So it didn't go to voicemail.
Well, I don't know that it didn't go to voicemail. I just know that I didn't receive a voicemail from him.
So if you, okay.
I mean, we're all guessing here, but I mean, he could have called voicemail.
We're not all guessing.
Well, you are, because you don't know if he left a voicemail or didn't, or at least got voicemail and then hung up the phone.
I think one of us is trying to guess.
Objection, Your Honor.
Sustained. You know what? I want to see counsel sidebar for just
6.
I'm giving you a lot of leeway for questions. Please calm down.
Yes, ma'am.
Are you now saying that your phone was open and unlocked at 2:22 a.m.?
I'm saying it could have been.
Are you saying that it was?
I don't know.
Mr. Albert, you were the only person that was there with your phone. Was the phone unlocked, and did you make a call?
Objection.
Can you answer that?
Sure, I don't know.
And 17 seconds later, again, presuming you're the only person there with the phone, did you answer that call?
I did not.
Here's why your knee pain keeps coming back, and the easiest way to fix it without pills, shots, or surgery.
Can I put your arm?
Yes. So show Mr. Rowley.
You could just look at this for a glance.
Okay.
And you can look up when your recollection is refreshed.
Okay, yep.
Does that refresh your recollection as to what you testified to
Sure, yes.
on May 18th, 2023?
Yes.
Isn't it true that you said that the second time you looked out, you saw that there was a black SUV that had pulled forward,
Yes.
but the truck was no longer there?
Sure, it seems like I said that then, yes.
You also testified earlier that you saw tire tracks in the snow, correct?
Yep.
Where were those tracks?
Just along the side towards the driveway along this way, going up towards the flagpole.
And you viewed those tracks kind of leading up towards the flagpole, correct?
Yes.
So you'd agree that the visibility and lighting in front of the house was good enough that you were able to see tire tracks in the snow, correct?
Sure.
But you did not see a 220-pound man lying in the snow in your front yard, did you?
Objection.
Was that something that you saw, so?
No, I didn't see that.
Who was in the house the second time that you looked out the window?
It would have been my mom, my dad, Brian Higgins, my sister, Julie, Sarah, Uncle Matt.
Mr. Albert, you testified on May 18th, 2023,
Mhm.
in another grand.
This is Colin Albert. This is the son of the homeowners, and also a potential suspect in the unaliving of John O'Keefe. It is believed that he may have gotten into a scuffle with John, and they were heavily leaning on him in the first trial.
Jury,
Mhm.
and you said, quote, "I'm not sure if Brian Higgins was still there. I know he left at some point." Do you recall that testimony?
I mean, I know he left my house at some point. I just don't know exactly when it was.
You were asked specifically at the time that you looked out the window, who was there? And you said, "I'm not sure if Brian Higgins was there."
Yeah.
Isn't that correct?
Okay, if I said that, yes, because I was not sure. I'm still not sure that if he was there or not.
So you're not sure whether Brian Higgins was there when you looked out the window, correct?
No. I'm not sure.
You have no independent recollection as you sit here today where Mr. Higgins was when you looked out the window, correct?
No.
You also didn't recall Mr. Higgins ever saying goodbye to you or your group, correct?
I believe that's true, yeah.
In fact, you actually testified before another grand jury on May 18th, 2023, that at some point Mr. Higgins just wasn't there anymore. I must have gone to the bathroom or something. I came back and I said, "Where did Higgins go?" And they said he left, correct?
Sure, yes.
You also testified before that grand
Objection, Your Honor.
So, yeah, I'm going to see you, Sidebars, if you could bring that, please.
So are these prior inconsistent statements, or are you just reading his testimony?
Well, those are prior inconsistent statements because he said that he just testified that Higgins was there.
Okay. What are you reading now?
I can rephrase it.
Okay. Don't just read that testimony. Okay.
Okay.
All right. Ask the question. And if it is a prior inconsistent statement, then you can impeach him. But don't just read it.
Sure.
When did your father leave in relation to Brian Higgins?
Leave? You mean like go upstairs, go to bed, or?
Leave your view.
He would have left after Brian Higgins had gone.
Mr. Albert, isn't it true that you weren't quite so sure about that when you testified on May 18th, 2023?
I don't know. You would have to show me.
Do you have a specific recollection of your father leaving after Mr. Higgins was gone?
Yep, I'm pretty sure he went upstairs after Brian Higgins left.
Mr. Albert, isn't it true that you told the grand jury, I'm pretty sure Mr. Higgins left first before my dad went upstairs, because he wouldn't have left if his friend was still there?
Yes, I just said that here as well.
You don't have any specific recollection as you sit here today where your father was or where Mr. Higgins was when you looked out the window that night,
No.
correct?
No, that's not true. I know that my father was in the room with us. I'm saying I don't know when Brian Higgins left the house. And when Brian Higgins left the house, then my father went upstairs into his bedroom.
But what you actually said was, quote, I'm pretty sure Mr. Higgins left first before my dad went upstairs because he wouldn't have left if his friend was still there, correct?
I see what you're saying. Yes, but I still say that my dad wouldn't have went upstairs until Brian Higgins left the house.
Right, and that's based on an assumption, correct?
Sure, yeah.
Because you weren't interviewed about this case until 18 months later, correct?
Yeah.
Caesar Milan, how to add years to your dog's life. Sardines.
9.
Bone broth.
10.
I guess I would ask, what do you consider an acquaintance? How would you define that term?
I would say an acquaintance is someone who you are friendly with and might see from time to time. I guess in my head, I'm just sort of thinking someone who's in closer in age with me. I usually think of it as more of like a friend type thing and not my father's friend to me. I guess that's just the way I think of it in my head.
Okay, so is your testimony before this jury that an acquaintance is really a friend?
Someone that you're friendly with, perhaps. Could be.
Okay. Have you watched any of the testimony in this case prior to your taking the stand today?
I have not.
Has anybody told you anything about any of the testimony that has occurred prior to your taking the stand today?
No.
Okay. Who is Katie McLaughlin?
Katie McLaughlin is a girl who I'm the same age as. We went to high school together. We graduated the same year. And
y'all remember that Katie McLaughlin was the EMS personnel that said she was not friends with her, but they went to high school together. They were in several photos together. This is Caitlin Albert, the daughter of Brian Albert and the sister of Colin.
we have a couple mutual friends. We interact with some of the same people socially. I can't think of a time, possibly ever, where her and I ever hung out one-on-one or individually.
Do y'all hear her?
So more of like a friend of a mutual friend.
Very detailed.
So, Kate, you would not consider Katie McLaughlin to be a friend?
She's not a close personal friend of mine.
If she was a close personal friend.
Objection.
Just let her finish her answer.
I'm sorry. Go ahead. Finish your answer.
I would not consider her one of my, again, close friends.
Okay, all right. So let's get back to my question. Would you consider her to be a friend?
Objection.
I'll allow that.
Your Honor, may we approach?
Why?
Juries, feel free to stand up and stretch.
They do not want this girl to say that she was friends with that daggone EMS lady. They was friends.
What is the objection?
Your Honor, as it pertains to this witness, I'm not sure what the relevance is of anything to do with her relationship with the firefighter that showed up at her house that morning.
Okay. What do you say, Mr. Yannetti?
What I say is that there has been testimony that she told Trooper Proctor that Katie McLaughlin told Rupert Proctor that my client looked at Jen McCabe and said, I hit him, I hit him, I hit him. Katie McLaughlin then testified before this jury to a brand new conversation that was back and forth involving multiple people. And she has admitted under oath that her testimony evolved, and that she also admitted it evolved after she learned that 34 Fairview was the Albert home. So this is directly on point to impeach Katie McLaughlin's characterization of their relationship as just acquaintances. We have multiple photographs putting them.
I understand. I don't see their testimony as different. Well, it's...
Right, I'm sorry. I cut the cord off.
So I think you've covered the same ground that you are covering, or maybe the end of you covering it. You're just shaking your head. So tell me what it is that you expect to ask of her now.
Okay, so I want to impeach her specifically, saying that she doesn't know. She's minimizing her relationship with Katie McLaughlin. You know, in addition to H, I, J, and K, which were the previous ones that were marked for identification, as I made the court aware, we received multiple photos after that, which were more incriminating in terms of putting the two of them together. They are arm in arm in a lot of photos. They are at a baby shower together, standing right next to each other in a small group. And this witness is with her 2 college roommates and 1 other person. And that other person is Katie McLaughlin. She is trying to distance herself, and it is crystal clear to me that she has either read social media or she has received some information about the cross-examination that Mr. Jackson did of Katie McLaughlin, where there was a big emphasis on her not being a friend, and that...
Why is that crystal clear to me? There is nothing before me that indicates that.
She used the exact language, which is, I was asking her if she was a friend. And she immediately jumped to, I don't consider her to be a close friend, which is exactly what Katie McLaughlin said as well.
Your Honor, it could also just be the truth.
Well, I'm entitled to explore what the truth is or what the truth isn't.
This season, you've got places to go, people to see, and things to do. You may have already gotten vaccinated.
I think we're just about finished with this. I know you feel differently. You don't have to agree with me. I'll give you one more question, but I don't think you're quite...
So I don't get to introduce any of the photos putting them together that depicts the actual relationship?
Not based on what I've seen here. What I'll do tonight is I'll go back through my notes on Katie McLaughlin. But for the same reason that she didn't get it with Katie McLaughlin, I don't see you getting it here. I'll give you 1 or 2 more questions.
Oh, they was
rather than take the 1 or 2 more questions, I'd rather move on to another topic and then revisit it tomorrow morning.
Okay.
Okay, Ms. Albert, you know Courtney Proctor, correct?
I know of her, yes.
And you've been in her company several times, correct?
Yes.
You've met her children, correct? Thank you. Please be seated.
You are unmuted.
Guys, this is a good place for us to pause. This is the next day, day 11. And I have got to get ready to get out of here. I cannot go into overtime today because I got plans with my girlfriends. So I think this is a good place for us to pause, put a pin in it, and start this. Listen, if you guys want bonus action tomorrow, tell me right now in the chat. We can come back and do day 11 tomorrow morning at 11 a.m. So if y'all want to do that, let me know right now. Just put a yes in the chat, and we can come back and do part 2 tomorrow morning. I will give y'all bonus coverage if you want it. So this is where I'm going to end for today, and we can pick back up and do a part 2 of this video. Remember, the world has never met another you. Go out and be great in it. Thank you guys so much for joining me on another Saturday to uncover these Karen Read Trial 1 sidebars. I am thoroughly entertained hearing all that was happening on the side where we weren't privy to, getting a better understanding of why the trial flowed the way that it didn't, or why it wasn't flowing at all, because she was all in the mix of everything. Right now, we are up to 8 sidebars and 1 voir dire in this trial. So, or on this day 10. So I'm going to see you guys. I see a yes. Okay, I'm going to see you guys tomorrow morning at 11 a.m. Do not forget to come back. I will send you guys a little note. Listen, have an amazing day today. Be great. Don't do anything that I wouldn't do. That means do all the things. Bye-bye.